Hello, my name's David Winch. I'm a forensic accountant with Bartfields Forensic Accountants. And today we're going to have half an hour on, in confiscation, the link, or sometimes the not link, between benefit, the defendant's benefit, and his available amount. And how does the benefit sort of make its way into the available amount? So let's have a look at the agenda. Start off with the statute, because I suppose we always have to start with the statute. And then I'm going to quickly mention several judgments that are often quoted, particularly by prosecutors. And then move on to look at those quotes in context a bit more, so that hopefully we better understand what they mean. And then talk about the current position, as I understand it, based on case law. And finally, I will mention how Bartfields Forensic Accountants can help with your forensic accountancy needs, both criminal and civil. Okay, so let's get into the statute to start with. And here we're particularly interested in section 7. Subsection 1 of section 7 says the recoverable amount for the purposes of section 6 is an amount equal to the defendant's benefit from the conduct concerned. So the recoverable amount is the benefit. That's our starting position in statute. But then subsection 2 says, but if the defendant shows that the available amount is less than that benefit, the recoverable amount is the available amount, or a nominal amount if the available amount is nil. So it's very clear from section 7 that the onus is on the defendant to show that his available amount is less than his benefit. Section 6, which is, if you like, the main operative section in relation to confiscation proceedings, and subsection 5 of section 6 says, if the court decides under subsections 4b or c that the defendant has benefited from the conduct referred to, and that will be either his general criminal conduct if he's got a criminal lifestyle, or his particular criminal conduct if he does not have a criminal lifestyle. If the court decides that the defendant has benefited from the conduct referred to, it must decide the recoverable amount, and we've just seen how it does that, and make an order, a confiscation order, requiring him to pay that amount. And that's where the legislation stood for some years, but has now been amended by adding paragraph B applies only if, or to the extent that, it would not be disproportionate to require the defendant to pay the recoverable amount. So we end up in a situation where the amount that the defendant's ordered to pay might be less than the recoverable amount. And here we're talking about A1, P1, we're talking about where, and so on. But note that under the statute, proportionality and disproportionality comes into play right at the very end. It doesn't come into play in deciding what the benefit is or what the available amount is. It comes into play after that, when you've calculated the recoverable amount, which is the lower of the benefit and the available amount, and then you're going on to decide, or the court is going on to decide, what the defendant should be ordered to pay. And at that very final stage, we consider proportionality, and we consider where and A1, P1. Anyway, A1, P1 isn't what we're talking about today, particularly. We're talking about judgments which prosecutors often like to quote in section 16 statements. And one of those concerns the case of Walbrook. Walbrook and Martin, sometimes called Walbrook and Glasgow. And I've noticed a couple of different spellings of Walbrook, but this quote goes like this. The burden of satisfying the court that the defendant's available amount is less than his benefit is on the defendant. Well, kind of, yeah, we've just seen that in section 7. And the quote is, in our view, this he must do by producing clear and cogent evidence. Vague and generalized assertions, unsupported by evidence, will rarely, if ever, be sufficient to discharge the burden upon the defendant. So this is the first time that we see this expression, clear and cogent evidence, used in the case law. Okay, let's move on to the second oft quoted judgment. This is the case of Barwick, or is it Barwick? I don't know quite how you pronounce it, but a 2000 case. And this is on the connection between the defendant's benefit and his available amount. And it says this: once it is proved that he has received the benefit, it is pragmatic and entirely fair to the defendant to place upon him the onus of showing, to the civil standard, that he no longer has the proceeds, or that their extent or value has diminished. Now that sounds to me like an absolute gold-plated quote for a prosecutor, because what it seems to be saying is, once you've got the benefit, then the onus is on the defendant to show that he doesn't still have that benefit. And of course, if he still has that benefit, then it's going to be part of his available amount, and anything else that he has will also be part of his available amount. So it's going to be straightforward, isn't it? We're going to just order him to pay the amount of his benefit. Third one, Telli. This is not quoted quite so much, but again, it's about the burden on the defendant. And it says this: if a defendant is found not to have disclosed the nature and extent of his realizable assets, a correct view of the statutory scheme is that he cannot satisfy a court that the total value of all his realizable property is less than the value of the proceeds of his drug trafficking. Now, the reason this one refers to drug trafficking is that it was dealing with a case not under POCA, but under the previous legislation and the drug trafficking arm of that previous legislation. But the implication is that under POCA, instead of proceeds of drug trafficking, what we can say is his benefit. So what this seems to be saying is, if the defendant's not disclosed the nature and extent of his realizable assets, a correct view of the statutory scheme is that he cannot satisfy a court that his available amount is less than his benefit. So again, sounds lovely for prosecutors. But let's look at these judgments in context. First of all, Walbrook. The issue actually in Walbrook concerned the value of a debt due to the defendant, which he said was uncollectible. And the full quote is this: where a defendant has an asset in the form of a debt, the onus is on him to satisfy the court that the realizable value of the debt is less than its face value. In our view, this he must do by producing clear and cogent evidence. Vague and generalized assertions unsupported by evidence will rarely, if ever, be sufficient to discharge the burden upon the defendant. So this was a case in which Mr. Walbrook was due some money, and he said, I can't get it, I won't be paid. The guy isn't going to pay me, that's not part of my available amount. And the court said, well, just standing there and saying that isn't going to cut it as far as we're concerned. We need more evidence. And that, you might think, doesn't sound unreasonable in that context. But a much more appropriate quote, if I may, in many cases comes from the case of Singh in 2008. And this was a case under POCA 2002. And this was a case about rebutting the Section 10 assumptions, which is where we often hear this about clear and cogent evidence put forward. So what did they say in Singh? Well, it said the judge was entitled to expect clear and cogent evidence on behalf of the appellant to displace those assumptions. He had before him manifestly dishonest evidence from the appellant, who must at that stage have been determined to deceive the court. He was entirely lacking in credibility. So this isn't perhaps quite as black and white as it appears. What was said in Singh, in effect, is that if you've got an entirely dishonest defendant, you can't believe a word of it. Indeed, the court finds that he's determined to deceive the court, then his word, unsupported by evidence, is not going to be enough to displace the assumptions. And that really shouldn't come as a surprise to anybody. Walbrook was referred to in another case as well, a case of Glaves, where this was said. The truth is that there is a balance of judgment to be struck. The courts are right to treat with some skepticism generalized assertions by someone whose credibility may be deeply suspect by reason of the facts of the offence. Absence of independent, credible evidence to corroborate a defendant's account is not fatal as a proposition of law, but it may well be fatal as a matter of fact. That, as I have said, is a matter for the judgment of the court considering the confiscation application. So what the Court of Appeal was saying in Glaves is it isn't a legal certainty that if there's no independent, credible evidence to corroborate the defendant's account, show's over. It may well be the case that in that situation, the court will decide that it's not persuaded by the defendant's evidence. But that is a judgment, a balance of judgment to be struck, and it's a judgment on the facts. It's not a proposition of law. So that's where we are with Walbrook. Now, Barwick. Interesting thing about the case of Barwick is that it concerned a con man who tricked women out of large sums of money. And the benefit in his case for confiscation purposes was made up entirely of monies which the defendant had obtained from these women. The benefit, it has to be said, was uplifted for changes in the value of money, uplifted for inflation, but was purely cash, or bank transfers if you prefer, which the defendant had obtained from these women. There was no assumed benefit at all in the case of Barwick. In fact, it was a case under the Criminal Justice Act of 1988 where there could be no assumptions. And there were no co-defendants. This was simply one man who'd stolen this money from these ladies. So the actual proceeds of the thefts and deception of which he was convicted were just a shade over £500,000, £502,595, before uplift for the changes in the value of money. And when they'd been uplifted, it came to about 600,000. Court of Appeal said that the court cannot necessarily assume, those were the words they used, cannot necessarily assume a change in the value of money uplift in relation to the available amount. It can and must in relation to benefit, but it cannot necessarily assume an inflation uplift for available amount. It can't assume that the defendant has obtained the benefit and invested it in such a way as to protect it from inflation. So you do not normally do an inflation uplift on the available amount. And in fact, in Barwick, the confiscation order was made for £450,000. The judge in the Crown Court said that was to acknowledge the fact that some of the money had gone. So even in the case of Barwick, even having said that, the judge said, yeah, but I recognise that although the defendant did have £502,000, did receive that, did obtain that amount of money, some of it will have gone, and we'll put an available amount figure of 450,000 on him. In other cases, the particular benefit may include elements from which no available amount can be derived. So, for example, if you've got somebody who's convicted of a drug trafficking offence and they're caught in possession of a kilo of cocaine, let's say, then the value of that cocaine will be a part of their benefit. Of course it will. But it isn't going to be part of their available amount, is it? We can't say their available amount is going to be equal to their benefit, because clearly there's an element there which has zero value to them in terms of available amount, because it's taken off them and in any event couldn't be sold, not legitimately anyway. So there's zero available amount in relation to that element of the benefit. And there may also be benefit in cases where there are more than one defendant, say a conspiracy case, where benefit has been obtained jointly. Now, if it's been obtained jointly, as we know, each person who jointly obtains that benefit obtains 100% of it for the purposes of calculating benefit. But clearly they can't all obtain 100% of it for the purposes of calculating their available amount, because, well, just as a matter of obvious fact, they don't each of them have all of it. So again, the available amount in that circumstance must be less than the benefit, or at least the available amount flowing from the offence must be less than the benefit. And there may be assumed benefit, for example, credits to bank accounts or cash expenditure, which demonstrably does not generate available amount. So if you've got money going into a bank account and it's assumed benefit, fine. But then if that's spent on ordinary living expenses, then that money isn't going to be an element in the available amount. I did a case recently in which the defendant had no bank account, but he'd been drug dealing in cash, and the benefit assumed that he must have had some cash to meet his day-to-day living expenses over the period since the relevant day. So you could look up some statistics and work out what his living expenditure might have been, and you could make an assumption, the expenditure assumption, that that must have been met from proceeds of his general criminal conduct. So yeah, there's benefit there. But is there available amount there? No, because he doesn't have the bacon and sausages which he bought from Tesco 5 years ago. He no longer has those as part of his available amount. They are not going to be readily transferable from benefit to available amount. So Barwick isn't telling us that we can just take somebody's benefit figure and assume their available amount is the same. We cannot do that based on Barwick. Telli. Now, as I said, the implication of the judgment in Telli, which we looked at a little while ago, appears to be that the Crown Court should find the defendant's available amount is not less than his benefit unless the defendant himself presents evidence which is accepted as credible by the court that his available amount is less. And we know, don't we, in practice, convicted defendants are not generally readily believed by courts, particularly when they've been convicted of an offence involving dishonesty, for example. So the defendant's evidence, unsupported by any documents or any corroboration, is not going to be accepted as credible in confiscation proceedings. So does that mean that the court must hold that his available amount is not less than his benefit? That the requirement of section 7, subsection 2, that the defendant shows that his available amount is less, cannot be satisfied? Well, that seems to be what Telli is telling us. But in the case of McIntosh, Lord Justice Moses said, yes, I have, he said, an opportunity to revisit certain dicta for which I must take responsibility in Telli, and to underline the importance of the statutory framework within which judges must work in order to assess the amount that might be realised. So what he was saying is that what he said in Telli perhaps had been taken out of context and somewhat misinterpreted. And in McIntosh, he wanted to revisit that and clarify the situation. So what is the current position? Well, in McIntosh, Lord Justice Moses said this. It's rather a long quote, I'm sorry, but he said this: "There is no principle that a court is bound to reject a defendant's case that his current realisable assets are less than the full amount of his benefit, merely because it concludes that the defendant has not revealed their true extent or value, or has not participated in any revelation at all. The court must answer the statutory question in section 71(6) of the Criminal Justice Act 1988, because McIntosh was a CJA 1988 case. The court must answer the statutory question in a just and proportionate way. The court may conclude that a defendant's realisable assets are less than the full value of the benefit on the basis of the facts as a whole." Continued, "A defendant who is found not to have told the truth, or who has declined to give truthful disclosure, will inevitably find it difficult to discharge the burden imposed upon him. But it may not be impossible for him to do so. Other sources of evidence, apart from the defendant himself, and a view of the case as a whole, may persuade a court that the assets available to the defendant are less than the full value of the benefit." So what the court here is saying in McIntosh is that actually, although the statute says the defendant must show, that actually the truth of the position is that the court must look at all the evidence, whether from the defendant or the prosecution or from other sources, and take a view based on the case as a whole, and may then conclude that the assets available to the defendant are less than the benefit. And indeed, the Law Commission did a consultation last year on POCA, and one of the proposals that they came up with in their consultation paper was that section 7 subsection 2 should be rewritten and redrafted so that it doesn't just say, as it does at the moment, that the defendant must show, but rather so that it reflects what's said here in McIntosh, that the court should look at the case as a whole, and if it then comes to the view that the available amount is less than the benefit, then so be it. Okay, so that's the position as we are today. I hope that's helpful. Let me just remind you how Bartfields can help with your forensic accountancy needs. We are in this pandemic, we are still fully staffed. We undertake legal aid and privately funded criminal work and civil work. Thankfully, it's relatively easy for us to conduct the bulk of our work remotely using our up-to-date and secure IT facilities. And we remain, of course, readily contactable by phone, by email, online, by video. The recently updated website is full of useful information. There is indeed an article on benefit versus available amount, which I put up there a couple of weeks ago, which covers much of this same ground. You can see more on this topic on our website, and this and our previous webinars will be on the seminars section of the Bartfields forensic website. This particular recording will go up in a couple of days. We will also email to you a free copy of the recording of the webinar. And of course, if you want to contact us, my email address is there. It's easier to contact me, frankly, by email than phone because I'm not in the office a lot. But drop me a line by email and I will respond just as quickly as I can. I hope you found this useful. Thank you very much for your time, and I will see you again in a fortnight. Thank you.